All rise, vous l'avez. Please be seated. Vous as well.
Judge Martak. I first hand over to the Office of the Prosecutor because I understand there's a change in the makeup of the prosecution team. Deputy Prosecutor, you have the floor.
Madam President, yes, indeed. One member of the prosecution team asks to be excused this afternoon, Ms. Jessica Lacey, and she is replaced this afternoon by Mr. Thomas Hope, Trial Support Assistant, on my left. Thank you, Madam President.
Presiding Judge, thank you very much, Deputy Prosecutor. Now I hand over to the defence. Mr. Edwards, you have the floor.
Thank you, Your Honour. Much, if not all, of this afternoon will be taken up with me speaking about 5 matters. I'll start by saying a few words about the prejudice caused to the defence by the huge volume of material in this case, specifically witness statements that the prosecution has relied on from witnesses whose identities have been withheld. I will then move on to talk about the prejudice caused by the unduly vague and imprecise language employed by the prosecution in the document containing the charges. And I'll then link those 2 matters together and speak about the specific prejudice that is caused by those 2 preceding points in terms of the defence's ability at this stage to advance any grounds excluding criminal responsibility and the ability to raise an alibi. I then propose to turn to the substance and speak for some time about the contextual elements of war crimes charged in the DCC. And it will be our submission that the prosecution has failed to produce anywhere near enough evidence of a nexus between any armed conflict and the charged crimes. And finally, I will pick up on a point, or the topic addressed by my learned friend this afternoon, and deal with the prosecution's attempt to persuade, or perhaps re-persuade, Your Honour's chamber to confirm charges of enslavement under count 13 and persecution under counts 14 and 16, insofar as they relate to Matiga detainees from East, West, Central or Southern Africa, referred to by the prosecution in the DCC as the black migrants. And it will be our submission that that attempt must fail. After I speak, lead counsel Mr. Hassan will take up the baton and continue the submissions that we have the honour to present on behalf of Mr. El Hishri. So, Your Honours, with your leave, I'll start with the problem of the secretive nature of the evidence in these pre-trial proceedings. You have seen from the prosecution's presentation over the last 2 days that they rely on the evidence of 63 witnesses, not 64. It's our understanding that the evidence of P1764 is no longer relied upon. Now, of these 63 witnesses, the defence has only been told the identity of 25. The identity of more than 6 out of 10 prosecution witnesses has been kept from us. It's been kept secret. And fully 1/3 of those anonymous witnesses have only been disclosed to the defence by way of carefully tailored summaries of parts of their accounts. Coincidentally, perhaps, but to illustrate the point, this is almost exactly the same ratio of secret witnesses as those cited by Madam Deputy Prosecutor yesterday morning during her opening remarks. She cited to seven witnesses, P 1046, 1031, 0644, 1673, 0943, 0872, and 1682. 7 witnesses about whose identity we have no idea whatsoever. And on top of that, as if a starker illustration is needed, 6 of the witnesses cited during Ms. Sampson's presentation on war crimes yesterday are anonymous witnesses. This is intolerable. It is unfair. The prosecution will tell you, and the public watching, that in fact this is fine, that this is the way of conducting international criminal litigation. It's provided for by the rules of procedure and evidence. This is how we do things at this court. The prosecution will no doubt say that for every witness whose identity has been withheld from the defense, applications were made to Your Honour's chamber. Your Honours have overseen that process, and Your Honours have made the rulings that you have. The prosecution will say, at the ICC, there's nothing to see here, this is fine. Now, we don't dispute for a moment that the process has been subject to Your Honour's oversight and supervision. Whether we agree with Your Honour's ruling is neither here nor there, of course, and I don't propose to relitigate it today. But I do want to say a few words about what some of the concrete consequences to the defence, what the consequences of those rulings are. The fact that such an important feature of pre-trial proceedings before this court can be shrouded in so much secrecy, can exclude the defence to the extent it is not fine. It may be permitted by the rules, and we don't dispute that, but that in itself doesn't make it fair. We described in our written notes and observations relating to the factual and legal elements of the prosecution's case against Mr. El-Hishri. That's filing 107, 28th of April 2026. We described that these proceedings are indistinguishable from secret proceedings, and we stand by that description. We have no idea who 60%, more than 60%, of Mr. El-Hishri's accusers are. Now, we've had the advantage of the prosecution's response to the defence's written notes and observations. That's filing 115 of 5th of May. And it has helpfully given us notice of its position ahead of this week's hearings. And essentially, in response, the prosecution make 4 points. That the rules allow them to hide evidence from the defense, that the defense's claims of prejudice are overstated, that there is, in fact, no unfairness, and fourthly, in dealing with the issue of anonymous evidence, the prosecution mounts an argument that becomes a theme, actually, throughout its response, filing 115, an attempt to sweep away the defence's concerns and complaints by a tactic that we think is not far from gaslighting, by saying that our concerns are based on pervasive misconception concerning the distinct nature of confirmation and trial proceedings. Essentially, they say, you, the defense, you don't understand. We, the prosecution, we understand. the rules. We understand how things work. But the defense, bless them, they don't get it. That's their position. Now, setting aside the sheer patronizing tone of the prosecution in that filing, the attitude serves as a distraction, an excuse for failing to deal with the real issue. Of course, confirmation proceedings are not the same as trial proceedings. There is no one in this room who doesn't understand that. The prosecution rather bizarrely states at paragraph 9 of its response that the defense concedes that confirmation proceedings are of limited scope and are not to be treated as a mini trial. A curious use by the prosecution of the word concedes here, Your Honours may think, since just a couple of paragraphs earlier, the prosecution suggests that the defense do confuse preparation for confirmation with preparation for trial. Gaslighting, Your Honours. None of that means that the defense should just keep quiet and accept it when served with anonymous witness statement after anonymous witness statement, or worse, anonymous summary after anonymous, carefully tailored summary. Unfairness and prejudice to the defense, not to any other party, have been baked into the confirmation of charges process at this court. The mere fact that the regulatory architecture of this court permits the withholding of identifying information from the defense does not, cannot, make that inherent prejudice, that inherent unfairness magically disappear. Nor is it any proper answer to our concerns and our complaints for the prosecution to say effectively, look, stop complaining. You've received some evidence from witnesses whose identity we've deigned to give you. We've thrown you some bones. It's no answer because the prosecution don't rely only on the evidence of identified witnesses. They rely on all the witnesses, the majority anonymous witnesses and the minority identified witnesses alike. So it's patently not an answer for the prosecution to say, you have not been treated unfairly because in addition to the unfairness, on occasion, you have been treated fairly. The prejudice to the defense in not knowing the identities of most of Mr. El-Hishri's accusers, especially those who say that they have been detained at Matika, is that we cannot carry out our own investigations into them. We cannot investigate whether these many individuals were, in fact, ever detained at Matika. Or if they were, why? Or if they were, from when? Or if they were, until when? Why does it matter? Why does it matter that we can't carry out these investigations? Well, we say that it's important in three main ways. The first way is that had we known the identities, had we been able to carry out investigations, it could allow us to establish at even this very early stage of proceedings whether there is any nexus between the detention of these individuals and the existence of any armed conflict, or whether their arrests were and detention was simply a matter of perfectly standard law enforcement. And we say that that's something that, if we were able to investigate, it's a matter that would not involve a conclusive determination of credibility, something that we understand at this stage Your Honours will not engage in. The second reason why this is important relates to the ability, or rather the inability, of the defence to advance any kind of alibi. Now, I'm going to deal with that a little bit later, but I just flag it up now. The third thing is, had we been told the identity of all of these witnesses, or even more of these witnesses, it would allow us to establish if any of these witnesses have provided their accounts to others apart from the OTP, to NGOs, to civil society activists, to national or international bodies charged with determining claims for refugee status. These are just by way of example. The point is, Your Honour, we simply don't know. We have been placed at a substantial disadvantage because of this secrecy. And the odds have been stacked against us in these proceedings. We've been placed in the same position, if I can use this analogy, as a person who goes into a casino and wants to play roulette, but is told, you can't bet on red or black. You can only play roulette on exact numbers. And the only numbers that you will be allowed to bet on are 4, 25, and 33. The odds of winning for such a gambler would be stacked against them. If you don't like the gambling analogy, let me put it this way. It's as if the defense is a boxer in a title match. But our opponent is 3 weight categories heavier. And we, the lighter boxer, have 1 arm behind our back. That boxer has practically no chances of prevailing. That boxer has the odds stacked against him. And that's where we are. Now, if the odds were not so heavily stacked against the defence, if the defence had a fair chance at contesting these confirmation proceedings, Your Honour could well imagine a situation, I'm not saying it's inevitable, but Your Honours could imagine a situation where, following a fair and sensible analysis of the evidence, that evidence doesn't quite stack up in the way the prosecution would want you to believe. Your Honours could well imagine a situation where huge holes in the prosecution's case are revealed, where, in fact, applying the standard appropriate for these proceedings, where there is simply not sufficient evidence to establish substantial grounds to believe that Mr. El-Hishri has committed the crimes charged, or at least some of them. Your Honour could even imagine a situation where it dawns on the prosecution at the conclusion of these proceedings that they simply don't have the evidence to go further, just as they did in the case of Mokom. Your Honours will recall that in that case, in contrast to the situation we are faced with, the defence had been provided with witness statements and prior statements of identified witnesses, and also transcripts of those witnesses' evidence in the case of Gaisona and Hekaton. And that gave the Mokom defense the opportunity to painstakingly compare and contrast these differing accounts and point out the plethora of contradictions and inconsistencies, fatal contradictions in the accounts of prosecution witness after prosecution witness until no reasonably reliable evidence remained. The consequence of which, of course, in Mokom, was that the prosecution concluded entirely properly that even if the charges were confirmed by the pre-trial chamber against Mr. Mokom, there was no reasonable prospect of a conviction at trial. That result in Mokom was only arrived at because the defense had been proved with the evidence of identified witnesses and could carry out its investigations. If those same considerations had applied in our case, Mr. El-Hishri's case, and to return to the boxing analogy, the prosecution may well have decided it had no option but to throw in the towel. As a result of which, Mr. El-Hishri would have been entitled to see the charges against him dismissed, to allow him to leave the detention center, to allow him to return to his family and his home a free man. But the odds are stacked against the defense. The secrecy gives precious little scope for the defense to prevail in these proceedings. And so Mr. El-Hishri, in all likelihood, has very little choice, very little chance other than to stay in detention while the wheels of this gargantuan edifice of the International Criminal Court slowly turn. I want to make it clear, we don't say that these confirmation proceedings were deliberately designed to be unfair and prejudicial to the defense, but it just so happens that that is the way they work. The prosecution have enormous latitude, and that is to the detriment of the defense. And that means the proceedings are unfair. I now move on to the second point, which is the unduly vague and imprecise language employed by the prosecution in the document containing the charges. We say that the prosecution has very deliberately, very carefully used the broadest and vaguest possible language in the DCC. Now, whatever the motivation for doing so, the consequence of this approach, we suggest, is that the prosecution has availed itself of the greatest latitude to mold its case post-confirmation against Mr. El-Hishri, depending on how the evidence unfolds at trial. That is unfair. It violates the spirit of 2 decades worth of international jurisprudence originating in the ad hoc tribunals. It also flies in the face of the appeal chamber's interpretation of Regulation 52B of the regulations of the court, to which we refer in our written notes and observations, but which provides that the document containing the charges, forgive me for reading, referred to in Article 61 shall include a statement of the facts, including the time and place of the alleged crimes, which provides a sufficient legal and factual basis to bring the person or persons to trial, including relevant facts for the exercise of jurisdiction by the court. Now, in our written observations, at paragraph 25, we cite to that appeals chamber decision. It's in the Bemba case. Filing, it's the judgment on appeal, in fact, filing 3636. And we cite to what in the Bemba judgment the appeals chamber expects of a DCC in order that it complies with the requirements of Regulation 52B. And this is what the chamber says. Simply listing the categories of crimes with which a person is to be charged, or stating in broad general terms the temporal and geographical parameters of the charge, is not sufficient to comply with the requirements of Regulation 52B of the regulations of the court, and does not allow for a meaningful application of Article 74(2) of the statute. In our submission, this is a relevant reference to the jurisprudence because it describes precisely what the OTP has done in this case. The document containing the charges really simply lists categories of crimes with which Mr. El-Hishri is charged and states in broad general terms the temporal and geographical parameters of the charges. So, if we look at paragraph, just by way of example, but if we look at paragraph 26 of the DCC, dealing with the allegation of torture, cruel treatment, imprisonment, outrages upon personal dignity, counts 1 to 6. And it starts, during the charge period, the Matiga perpetrators violently arrested, detained, and systematically mistreated at least 5,140 persons, principally at Matiga prison. So looking first at the temporal parameters of the charges, during the charged period, you could not imagine a broader exposition of the temporal parameter. Because we know from paragraph 1 of the DCC that the charged period is a period of 6 years and 2 months. And then in terms of the geographical parameters of the charges, Matiga prison, well, that's fine. But what they say is, the prosecution, principally at Matiga prison. What does that mean? That's not acceptable. It's overly broad. It is impermissibly vague. If certain charged crimes were committed in locations other than Matiga prison, for goodness sake, tell us. One searches in vain in the document containing the charges for some indication of geographical parameters that is more precise, that is more than put in broad general terms. The best one can find is paragraph 8 in the DCC, when describing the contextual elements of the crimes against humanity, where the prosecution talk about the widespread and systematic attack directed against the civilian population in and around Tripoli. It's not much better. We say that that is a perfect example of merely stating in broad general terms the temporal and geographical parameters of the charges faced by Mr. El-Hishri. Now, the prosecution argue at paragraph 23 of their response that identification of temporal and geographic parameters need not be provided with precision in the DCC, but does acknowledge the prosecution that the Bemba appeal judgment observed that overbroad identification of such parameters is inappropriate. We say that the Hishri document containing the charges is a paradigm case of overbroad and therefore inappropriate specificity. And we urge Your Honour's Chamber to put the prosecution right and order the prosecution to do their job properly. The prosecution also argues that the defence conflates matters of relevance to the formulation of the charges, which must be determined by the Chamber, and matters relevant to notice under Article 67(1)(a). If that's what the prosecution think, then that would suggest that the prosecution has either not read or has fundamentally misunderstood or has chosen to misunderstand the defence's observations. The prosecution also rather alarmingly suggests at paragraph 16 of their response that its duty to provide adequate notice to the defence can be outsourced to Your Honours, subcontracted to the pre-trial chamber. The prosecution suggests that the defence ignores that notice provided in the pre-confirmation brief can potentially be supplemented with further notice to be given in the reasoning of the confirmation decision itself. So in other words, it seems to be suggested that Your Honour's Chamber can do the prosecution's job for them, at least in part, by analysing the evidence and giving the defence the full and proper notice the prosecution, should be giving. It's an extraordinary shirking of responsibility, Your Honours may think. The prosecution suggests that the pre-trial chamber should accept to undertake a job that you are not and never have been designed to do. So this, we say, is a perfect opportunity for Your Honours to set the record straight and to remind the OTP in no uncertain terms that they are the ones who bring the case against Mr. Hishri. They are the ones expected to develop and advance a case strategy. They are the ones who have the responsibility to disclose the details of their case. And your job is to oversee that process, to referee that process. It should never be the case that it is for pre-trial judges to give the accused detailed notice of the case. Of the case that he must face in the reasoning in the confirmation decision. And that is not what the appeals chamber in the Ongwen judgment found. If the prosecution truly believe that that is how the various duties of the different actors at this court should be apportioned, the prosecution must be disabused of that belief without delay. I don't want to spend an unduly long time on this point of vagueness and the lack of precision, because we set out the examples of the imprecision as we find it in paragraphs 22 and 23 of our written notes and observations quite fully. But in sum, can I just put it this way, we say that Regulation 52B has not been respected in the formulation of the DCC. I mean, just in terms of an example, as much for the public as anyone else, but in terms of the charge of imprisonment, the prosecution sets out the fundamental rights of which detainees were deprived, so they say. But instead of providing an inclusive list of these rights, the prosecution non-exhaustively charges including but not limited to. To employ the terminology in the Bemba appeal, that is not sufficient to comply with Regulation 52B. Another example, just very briefly, of the vagueness in the DCC in terms of the identification of perpetrators and co-perpetrators. The prosecution argue at paragraphs 18 and 19 of their response that not every alleged perpetrator or co-perpetrator needs to be identified. And we accept that. As a matter of law, that may be right. But as much precision should be provided as possible than the vaguest of vague terminology that the OTP elects to use when it talks about the Matiga prison leadership or the Matiga perpetrators. In concrete terms, Your Honours, what on earth do those groups encompass precisely? We simply cannot know because they've chosen not to tell us. When we turn to the pre-confirmation brief to see if there are any clues in that document about, for example, who precisely the Matiga leadership is, we are left scratching our heads. Only 3 names are given, the same 3 names that were put up on the screen this morning in terms of the Matiga leadership. But again, couched in terms of vagueness, including these 3 people, or Mr. El-Hishri and these 3 people. We have to know, in order to be able to carry out our investigations, in order to be able to adequately defend Mr. El-Hishri. But the clear decision, and I dare say the tactical decision on the part of the prosecution not to tell us, makes our job impossible. There's also a sort of a fundamental and unacceptable circularity of reasoning in the prosecution's attempt to define the Matiga perpetrators on a functional basis. They essentially say that the defense is on notice of who the Matiga perpetrators are by virtue of the fact that they are perpetrators of crimes at any given time at Matiga. It's a self-identifying group, but it's utterly unhelpful. It is vague by design, precisely designed so that the prosecution can feel itself at liberty to mold its case to the evidence as that evidence reveals at trial. And it should not be allowed. I move on to my third point, and this focuses on the specific prejudice that is caused by the 2 preceding points in terms of the defense's ability at this stage to advance any grounds for excluding criminal responsibility or raising an alibi. Now, Your Honours will recall inviting the defence in its written notes and observations to set out grounds, any grounds, for excluding criminal responsibility or raising the existence of an alibi in accordance with Rule 79.1 of the Rules of Procedure and Evidence. And at Section 7 of our written notes and observations, we indicate that the defence advances no grounds for excluding criminal liability at this stage, but that this is without prejudice to the defence's right to revisit its position before the trial chamber if the charges are confirmed. The main reason for the defence's inability in this respect is the extraordinarily wide charged period about which I spoke a few moments ago, and the general imprecision of dates on which Mr. El-Hishri is alleged to have committed the charged crimes. We simply are not in a position to raise the existence of any alibi in any meaningful sense of the word. We're also unable to raise any meaningful alibi because of the very confidentiality of so many prosecution witnesses. What do I mean by that? Because it may not be obvious. If we knew the names of all the detainees, this would allow us, or might allow us, to establish with greater certainty when any such witnesses were detained. And if we had some clarity about that, any clarity of approximately when Mr. El-Hishri is alleged to have committed the crimes with which he is charged, beyond this ridiculously wide charged period of 6 years and 2 months, that may allow us to establish whether Mr. El-Hishri had an alibi worthy of the name. Mr. El-Hishri was in possession of a passport. He had the ability, and indeed was in the habit of travelling during the charge period. Establishing solid alibis, meaningful alibis, for definite periods of time could well result in Your Honour's chamber concluding that for some charges at least, there is not, after all, sufficient evidence to establish substantial grounds to believe that he committed the crimes charged, or some of the crimes charged. And the same holds true, albeit to a lesser extent, I accept, in terms of advancing any grounds for excluding criminal responsibility provided for in Article 31(1) of the Rome Statute. The prosecution responded to what we say about our inability to advance an alibi, and in a curious choice of language, submitted that Mr. El-Hishri has declined to provide notice of any alibi. Declined. Well, the underlying sense of that word being that if Mr. El-Hishri wanted to, he could have given details of an alibi, but he has taken a positive decision to keep it secret at this stage. Your Honour's utter nonsense. The prosecution's suggestion that he can provide an alibi that would be worth the paper it's written on for a period of 6 years and 2 months, and from a location that is as broad as it is set out in the DCC, is laughable. The prosecution knows, the prosecution should know, that alibis have to be precise, sometimes to the hour, sometimes to the minute. Alibis, if they are meaningful in any sense of the word, cannot be vague. What value would an alibi be to an allegation that, just by way of example, Mr. El-Hishri shot an unnamed detainee in the knee on an unknown date? If the only alibi we could advance is that for 2 weeks in, June 27, maybe it was July, he was on holiday with his family. Of course, we can't provide any kind of meaningful alibi, given the broadness and the vagueness of the DCC. And the prosecution, frankly, falls back on the laziest of responses by saying that Mr. El-Hishri is best placed to know where he was at the time without there being a requirement for any investigations by the defense. Well, the most generous thing that we could say is that the prosecution's retort demonstrates a fundamental naivety about how criminal litigation works. We're confident that Your Honours don't operate under the same naivety, and that you have a far superior understanding of the realities of criminal litigation. But about that, I will say no more. Contextual elements of the crimes. Now, probably now, where are we? It'll probably be tomorrow now, but Mr. Hassan, our learned lead counsel, will address you on the contextual elements of crimes against humanity, probably tomorrow now. The prosecution, at paragraph 35 of their response to our written notes and observations, argue that undeveloped submissions must be disregarded. Because, and it's fair to say, we don't go into much detail about the contextual elements of crimes against humanity in our written notes and observations, but the prosecution completely ignores, of course, what we say at paragraph 2 and then again at paragraph 46 in our notes. That those notes were never intended to be the defence's only and final word on the arguments that it wishes to advance in these proceedings. The defense made it absolutely clear that these notes should not be understood to amount to a comprehensive treatment of all the arguments that the defense wishes to address before Your Honours. And lest there be any doubt, the defense made it clear again in its conclusion, and I'm going to cite it in full. For the foregoing reasons, which will be complemented and fully elaborated upon during the confirmation of charges hearing, the defense will respectfully request that the pretrial chamber decline to confirm any of the charges. We made it clear that this is like a skeleton argument, and the prosecution ignored those caveats in a rather grumpy and unfair submission, asking the chamber to ignore allegedly undeveloped arguments. But anyway, that's a matter for Mr. Hassan tomorrow. I'm going to focus now on the insufficiency of evidence of a nexus between the alleged armed conflict in Libya at the material time and the charged crimes. Because I'm not wearing my headphones, can I just check with the interpreters I'm not going too fast? Thank you. We said in our written notes and observations, and we reiterate now, that the circumstances of the alleged arrest and detention and alleged mistreatment of the complainants at Matiga had no or no sufficient nexus with any non-international armed conflict. I'll shorten that to NIAC for the rest of my submissions. Now, we accept that whether a nexus has been established or not is a fact-sensitive exercise. We agree with what the prosecution submitted yesterday. We focus on paragraph 40 of the pre-confirmation brief, where the prosecution say this: notably, but for the conflict and the power vacuum and factionalism which had been created by it, the NIAC, the Matiga perpetrators could not have carried out the alleged crimes at all, or in any event, in a similar institutionalized and sustained way. And that language mirrors, doesn't it, the prosecution submissions in its application for an arrest warrant against Mr. El-Hishri. The prosecution said this: the alleged crimes in Matiga prison all had the requisite nexus. In particular, SDF RADA members could not have committed the crimes without the conflict which enabled SDF RADA to maintain its exclusive control of Matiga prison where the crimes occurred, and they go on. This is the heart of it. Without the conflict, say the prosecution, the Libyan authorities would not have permitted SDF RADA to function as it did. As such, the conflict was an essential condition for the prolonged and systematic commission of crimes at Matiga prison. So that's from paragraph 50 in the arrest warrant application. Your Honour will note the but-for test in that application, and that was the key test advanced by the prosecution. And Your Honour's chamber agreed. In your decision, the warrant of arrest decision, paragraph 14, you state in the clearest terms, Your Honours, the key question is why the alleged victims were detained. Alleged victims in square brackets. Even if an armed conflict is ongoing, not every detained person falls within the scope of IHL, especially when it concerns a government prison. A perfectly valid bit of judicial reasoning. It's plainly obvious. The prosecution say, well, in fact, the but-for test is only one factor for the pretrial chamber to take into account as part of a wider and more holistic approach. There are other factors that must be examined. And so, in its pre-confirmation brief, paragraph 40, the prosecution argue that when considering this nexus requirement, the chamber should consider, in particular, 4 factors. 1, the affiliation of the Matiga perpetrators to SDF RADA and the GNC/GNA as a party to the conflict. That's 1. 2, the status of the victims as civilians or fighters hors de combat. Thirdly, the commission of the relevant conduct by the Matiga perpetrators in the context of their official functions. And fourthly, the substantial part played by the NIAC in enabling the Matiga perpetrators to carry out the relevant conduct, the manner in which it was committed, and or the purpose for which it was committed. With Your Honour's leave, I'd like to start by discussing the sources of the applicable standard for determining whether a nexus exists. And a good point to start is the elements of crime. That publication of this court, or that fundamental text of this court, states that for criminal conduct to amount to a war crime, the conduct must have taken place in the context of and was associated with an armed conflict not of an international character. In terms of international criminal jurisprudence, the starting point in any examination of the nexus requirement is the Kunerat's judgment before the ICTY, the appeals judgment, actually. And I hope Your Honours will forgive me by reading out from 1 or 2 paragraphs, because it is it's interesting to remind ourselves of what is said in Kunerat's. Because you'll agree with me, I think, that what is said in Kunerat's not only is a good starting point, but it makes absolute sense. Paragraph 58, Kunerat's. What ultimately distinguishes a war crime from a purely domestic offence is that a war crime is shaped by or dependent upon the environment, hyphen, the armed conflict, hyphen, in which it is committed. it need not have been planned or supported by some form of policy. The armed conflict need not have been causal to the commission of the crime, but the existence of an armed conflict must, at a minimum, have played a substantial part in the perpetrator's ability to commit it, his decision to commit it, the manner in which it was committed, or the purpose for which it was committed. Hence, if it can be established, as in the present case, that the perpetrator acted in furtherance of or under the guise of the armed conflict, it would be sufficient to conclude that his acts were closely related to the armed conflict. And then moving on to paragraph 59. In determining whether or not the act in question is sufficiently related to the armed conflict, the trial chamber may take into account, inter alia, the following factors. The fact that the perpetrator is a combatant, the fact that the victim is a non-combatant, the fact that the victim is a member of the opposing party, the fact that the act may be said to serve the ultimate goal of a military campaign, and the fact that the crime is committed as part of or in the context of the perpetrator's official duties. Kunarat's was discussed in the ICTR appeal judgment in Rutaganda. And in that judgment, paragraph 570, the chamber says this, that they agree with the criteria highlighted and with the explanation of the nexus requirement given in Kunarat's. But what the appeals chamber says in Rutaganda is this: it is only necessary to explain two matters. First, the expression under the guise of the armed conflict does not mean simply at the same time as an armed conflict and or in any circumstances created in part by the armed conflict. So I pause there. That really is just an exposition of the obvious. But the appeals chamber in Rutaganda gives an example, and it is a useful example. It is illustrative. So they say this, for example, if a non-combatant takes advantage of the lessened effectiveness of the police in conditions of disorder created by an armed conflict to murder a neighbor he has hated for years, that would not, without more, constitute a war crime under Article 4 of the statute. And I pause for a moment to say that that kind of example is the sort of example that we will urge you to bear in mind throughout the rest of these submissions and indeed in your consideration of in these confirmation proceedings. The appeals chamber in Rutaganda contrasted that example with Kunarat's himself, because they say the accused in Kunarat's, for example, were combatants who took advantage of their positions of military authority to rape individuals whose displacement was an express goal of the military campaign in which they took place. And then I jump forward a bit. Particular care is needed when the accused is a non-combatant. And then moving from the ICTY and the ICTR to this court, in the Afghanistan situation, the appeal judgment cited by my learned friend yesterday, 5th of March 2020, that case. At paragraph 69, the appeals chamber says, it has been observed that the function of the nexus requirement is to differentiate war crimes from ordinary or common crimes under domestic law, such as the common crime of murder and rape. The appeals chamber cites to Kunarat's, and also states this at paragraph 70, the appeals chamber endorsed this approach in the Taganda case, whilst also noting that, and I cite, any undue expansion of the reach of the law of war crimes can be effectively prevented by a rigorous application of the nexus requirement. So, whilst we agree that the nexus question is a fact-sensitive question, we endorse that which is said by the appeals chamber in Afghanistan, that we must always be wary not to get involved in undue expansion of the reach of the law of war. A rigorous application of the nexus requirement is always needed. It's when the right questions have been identified and asked that we see that in Mr. El-Hishri's case, those answers don't assist the prosecution. So, looking at the factors mentioned in Kunarat's, is the perpetrator a combatant? Well, here, there's no evidence that Mr. El-Hishri is a combatant in any NIAC in Libya. Were detainees combatants or non-combatants? Well, the vast majority were non-combatants. The vast majority of detainees were arrested and detained on the prosecution's case for reasons entirely unconnected with any status, any combatant status. So we're looking at arrest and detention on the basis of religion, sexuality, perceived moral misbehavior, ethnicity, immigration status in Libya, and so on. Perceived opposition to the interests of RADA. Now I say the vast majority, even where the prosecution states that persons were detained on the basis of suspicion of membership of an armed group, for example, ISIS. Your Honour's chamber must carefully assess whether the arrests were made on the basis of some suspicion of combatant status, or in fact, for much more straightforward reasons, connected with ISIS members' affiliation or suspected affiliation with a terrorist organization. In which case, of course, any arrest would be perfectly justifiable on the grounds of domestic law enforcement reasons. Every country in the world has the right to arrest and detain suspected terrorists because terrorist activities are crimes, including very often, in many jurisdictions, simple membership of terrorist organizations. So just because somebody has been arrested on suspicion of ISIS, you cannot jump to the conclusion that that is because they were a suspected combatant. Thirdly, the fact that the arrest or detention may be said to serve the ultimate goal of a military campaign. Here, the prosecution has produced no evidence whatsoever that any of the alleged arrests served the ultimate goal of any military campaign. The fact that a crime is committed as part of or in the context of a perpetrator's official duty. Again, there is no evidence that Mr. El-Hishri, even on the prosecution's case, no evidence at all that he had any official duties associated with military matters or combatant matters. So that's running through the list of questions identified by Kunarat. Let's now come to the factors identified by the prosecution at paragraph 40 of its pre-confirmation brief. let's have a look at the factors of relevance in this case. They ask you to look at the affiliation of the Matiga perpetrators to SDF RADA and the GNC GNA as a party to the conflict. We say that really the important question for you to answer is whether SDF RADA itself was connected to any NIAC. Any association with the GNC or the GNC GNA without more is in our submission too remote to tie SDF RADA as an organization to the armed conflict. And that's just talking about the organizations. The same goes to a greater extent with regard to the Matiga perpetrators, whoever they may be, and much less still to Mr. El-Hishri himself. Care must be exercised, we respectfully submit, by Your Honour's Chamber to avoid the undue expansion of the reach of the law of war crimes by undertaking a vigorous application of the nexus requirement. The prosecution say you have to look at the status of the victims as civilians or fighters hors de combat. Well, yes, exactly. The vast majority of detainees were not fighters. They were civilians on the prosecution's case. But if there is evidence of fighters hors de combat or any suggestion that detainees were fighters hors de combat, the evidence would suggest that they were arrested for reasons associated with their criminal membership or association with a terrorist organization as prescribed under Libyan municipal law, rather than as fighters or former fighters per se. And then we look at the point raised by the prosecution, the substantial part played by the NIAC in enabling the Matiga perpetrators to carry out the relevant conduct, the manner in which it was committed, and or the purpose for which it was committed. And here, Your Honours, there is a real danger of overreach, we say. The existence of an armed conflict as an enabler of perpetrators to carry out their criminal conduct cannot in and of itself reliably create a war crime nexus. And I come back to the very example given by the ICTR Appeals Chamber in Rutaganda of a non-combatant taking advantage of the lessened effectiveness of the police in conditions of disorder created by an armed conflict to murder a neighbour. That is an observation that is as pertinent today and as obviously correct today as it was all those years ago. And then, coming now to the but-for test, it's part of the holistic assessment. But for the conflict, say the prosecution, and the power vacuum and factionalism which had been created by it, the Matiga perpetrators could not have carried out the alleged crimes at all, or in any event in a similar institutionalized and sustained way. Here we say that whilst it's right that this be a question that is considered as part of the holistic and multifaceted approach to be taken, here we say this is the prosecution engaging in pure speculation. It's the prosecution imagining a counterfactual, an alternate history. But by counterfactual, I mean an expression of what has not happened, but could, would, or might under differing conditions. So, in the case at hand, if there had been no NIAC, the Matiga perpetrators would not or could not have carried out the alleged crimes, and Mr. El-Hishri would not be here. We argue that this is the prosecution inviting Your Honours to engage in the most soaring and the most dangerous speculation. that has no place in a court of law, in a place where what is required is evidence. Yet the prosecution points to no convincing material in the pre-confirmation brief to support the sweeping assessment that arrests and detention of persons for domestic criminal offences and the alleged arrests and detention of persons for example, broader ideological reasons could not have been carried out in precisely the same manner or indeed in any other manner in the absence of the NIAC. On any reasonable and impartial and dispassionate view of the evidence, we are confident that Your Honours will find that there is simply no sufficient evidence to establish substantial grounds to conclude that a nexus exists between any NIAC in Libya and the crimes alleged against Mr. El-Hishri. My final topic before you this afternoon focuses on our response to the prosecution's attempt to persuade this chamber to confirm the charges described as, by the prosecution, the alleged mistreatment of persons described by the prosecution as black migrants. So we're talking about enslavement in count 13, and persecution on political grounds, count 14, and on nationality, race, and or ethnicity grounds, count 16. Count 13, enslavement, finds itself in the DCC, doesn't it? The prosecution had valiantly, albeit in a state of some over-optimism perhaps, attempted to convince Your Honours that enslavement should be included on the arrest warrant. And it will be recorded that Your Honours, having examined the evidence that you had been shown, you declined to include enslavement. And, if I may, your reasons were beyond reproach. You said this at paragraph 81 of the warrant of arrest decision. The Chamber also notes that the prosecution defines the civilian population targeted by this crime of enslavement as segments of the population in Libya perceived to be opposing SDF, RADA, or its ideology. The material provided indicates that the sub-Saharan detainees, as they were described in the arrest warrant application, were detained for reasons unrelated to opposing SDF, RADA, or its ideology, and therefore cannot be considered part of the same civilian population that was being attacked. Regarding the other detainees, because it wasn't just the sub-Saharan detainees, it was other Libyan detainees, the Chamber considers that the prosecution has failed to show that the alleged perpetrators exercise powers attaching to the right of ownership over them. Based on these considerations, the Chamber will not further examine the alleged crime against humanity with respect to both sub-Saharan African and Libyan detainees. It is worth highlighting for the benefit of the public, if for no one else, that at the stage of pre-trial litigation relating to the request for an arrest warrant, the standard of proof demanded in the Rome Statute is very low. The prosecution does not have to bring enough evidence to satisfy the court of its request beyond reasonable doubt. That's the standard for trial. The prosecution doesn't even have to meet the test of bringing sufficient evidence to establish substantial grounds to believe that the target of the warrant has committed the crime for which the prosecution wants to arrest him or her. That is a lower standard than beyond reasonable doubt, and it's in fact the standard applicable at these confirmation of charges proceedings. To succeed in a request for an arrest warrant, all the prosecution has to do is place enough evidence before the Chamber to satisfy the judges that there are reasonable grounds to believe that the target has committed the crime for which the prosecution wants to arrest him or her. It is a low standard. It's the lowest standard, in fact, applicable before this court. It's similar to the standard of probable cause that's familiar to American jurists. The standard to be applied by grand juries in the United States when deciding whether to issue a criminal indictment. There's another similarity between the American grand jury procedure and the procedure to be followed for the issuance of an arrest warrant at this court. They are both ex parte the defense. So what happens? The prosecution puts forward its best case without any fear of contradiction from the other side. It's not an adversarial process. And because it is so one-sided, and because the applicable standard is so low, it is a famous idiom in American legal circles that a grand jury would indict a ham sandwich. Returning to this case, even on the lowest standard, the arrest warrant standard, Your Honours were so utterly unpersuaded by the prosecution's arguments and evidence regarding enslavement that you declined to further examine that crime. Quite rightly, if we may say. And now that the test is that much higher, the prosecution attempts to resurrect enslavement as a crime against humanity. But now, the standard is more onerous, the substantial grounds to believe. Your Honour, this attempt must fail. We, in our submissions, refer to Article 101 of the Rome Statute, which defines the rule of specialty. I see the time, so I'm not going to read it. It's not impermissible or a violation of the principle of specialty to add charges prior to the confirmation hearing which were not contained in the arrest warrant if they are part of the course of conduct for which the suspect was arrested. And the authority for that proposition is Barushimana. But our case today, Mr. El Hishri's case, can readily be distinguished from Barushimana because you have already ruled, and to a lower standard, that the allegation included in the prosecution's request for the arrest warrant relating to enslavement was simply not made out. The prosecution has not shown that that ruling was wrong, and there is no basis to believe that Your Honours should arrive at a finding that is in any way different to your prior and plainly correct findings that the black migrants were detained for reasons unrelated to opposing SDF-RADA or its ideology and cannot be considered part of the same civilian population that was being attacked. And the prosecution has failed to show that the alleged perpetrators exercised powers attaching to the right of ownership over the Libyan detainees. And so for those reasons, we say that you should and you must decline to confirm count 13. And for exactly the same reasons, because the prosecution have produced no evidence that the sub-Saharan detainees or the black migrants were detained for reasons related to opposing SDF-RADA. For the same reasons, counts 14 and count 16, insofar as they relate to black migrants, must also be refused. Your Honours, that brings me to the end of those 5 points that I had. There's one final point, and I'm just going to take up one moment of your time, if I may, because this morning, just before the lunch adjournment, when dealing with the question of modes of liability, Mr. El Hishri's alleged modes of liability, the prosecution stated, didn't they, that they charge him under 4 sub-articles of the Rome Statute. for the sake of judicial economy. Can I put it this way? They throw the kitchen sink at Mr. El-Hishri for reasons of judicial economy, whilst at the same time stating clearly that on their case he directly perpetrated acts under each of the crimes charged. So we ask ourselves this, and we invite yourselves to ask yourselves this question. If judicial economy is the concern, why not just charge him with direct perpetration under Article 25.3a of the Rome Statute and be done with it? It's difficult to understand why they don't simply pin their colours to the mast. We wonder, in fact, we suggest that this is a sign of prosecutorial timidity. What they're basically saying is, we're going to throw everything at the court and let the judges pick the bones out of that. But that's not fair. That doesn't give us notice of what the way in which the prosecution really put their case against Mr. El-Hishri, and judicial economy cannot be the reason for the way in which they put their case, because that will require at trial significant amounts of time in calling evidence and dealing with evidence that deals with all the other sorts of modes of liability that require additional evidence. Judicial economy cannot be the reason. Your Honours, I thank you for your time. Those are the submissions that I have to make a little bit before 3 o'clock. Unless Your Honours have any questions for me, that's where I propose to stop.
Judge Motag. Thank you very much, Counsel. I've consulted my colleagues. I'd like to thank you, but we have no questions. How do you proceed from here, members of your defence team?
Thank you, Madam President. We need approximately 1 hour and a half. Therefore, the remaining time for today will be insufficient, and we will have to interrupt our submissions. So after your permission, we would like to start tomorrow.
Judge Motag, so if I've understood, you wish to finish a hearing now and start early to put your submissions. Is that right?
C'est ça, oui.
Judge Motag, have I got that right? Microphone, please, Your Honour. Judge Motag, so I've consulted with my colleagues. We are in agreement with defence's proposal. We will rise now. I'd like to thank all the parties and all the participants, the court reporters, and we shall reconvene tomorrow. Oh, you wish to make a submission, prosecution? Microphone, please, says the interpreter. Microphone for the presiding judge. So we shall see each other tomorrow as scheduled. Thank you very much. We rise.
All rise, veuillez vous lever.